evidence going the other direction. And that is what happened here. So yes, there was one, you said experts who said he was competent. There was only one, Dr. Ballinger, who had never performed a competency exam before and whose evaluation was inconsistent and actually in some ways supported our argument that there was a...
Are you asserting that Dr. Ballinger is not competent to be an expert?
No, I'm not saying that. I'm not.
So if Judge Gergel hears Dr. Ballinger and he hears Dr. Ballinger say, and I think what he said was that Roof was not controlled by mental illness, but had a logical extension of his political and social beliefs in doing what he did. If Judge Gergel hears those things from somebody who's competent to render an expert testimony, on what basis would we say that's a clearly erroneous judgment by the district court?
It was clearly erroneous because the court did not address any of the substantial contrary evidence, which was 5 experts who said that Roof had a history of suffering from delusions, both race war delusions and somatic delusions, medical records documenting years of suffering from these delusions, Dr. Ballinger admitting that he hadn't reviewed all of those records, never addressing them. So Dr. Ballinger's opinion is worth what it is, but he only addressed what Mr. Roof told him after November 7th and before November 22nd, which was during the period of time when Mr. Roof had gotten wind that his mental illness would be publicized, which would thwart his eventual rescue by white nationalists. And at that point, he started covering up all of the delusions that he had previously spoken about. So the court committed clear error by ignoring 9 months of statements that are very consistent, documented by 5 different experts and defense counsel. Defense counsel, 3 attorneys did a sworn affidavit talking about...
Just ignored it? The district court just ignored it. It's not that the district court's opinion can be read as saying, I believe he's competent, I believe this expert.
Well,
you think that the record is so clear that the district court just ignored it, that it constitutes clear error. That's the legal position you got, right?
Well, my legal position is that it ignored it actually at the second hearing where the court declared it was not going to consider any of these medical reports. So yes, that it was an abuse of discretion to block the evidence, and it resulted in a clear error because it substantively ignored evidence. At the first hearing, it didn't exclude evidence, but what the court said was after hearing from all of these experts, Ballinger, Stayskull, Maddox, and Ballinger. Yeah, the court said only one defense expert said that Mr. Roof is incompetent and relied on Maddox. But that was not the case. Dr. Lofton submitted an affidavit saying that Mr. Roof did not fear death sentence because he did not believe he would really be executed. He emphatically believed he would be rescued after the race war. Dr. Stayskull said the same thing. He said, although he needed more time to reach the ultimate issue of whether or not Mr. Roof was competent, he had deep concerns because he saw evidence of a schizophrenia spectrum disorder based on this history of delusional beliefs that he had, and that he did not seem to take seriously the threat of death. And the court did not address any of those in its first decision. In the second decision, it didn't even consider them.
Well, counsel, let me interrupt you. I've got to interrupt you. I don't mean to interrupt Judge Jordan there. But the judge said, Joint Appendix at 5529, he, quote, read every one of their experts, and that's at the second hearing, right? He says he read every one of them. He also says that Ballinger reviewed all those reports and discussed them with Roof. And I know that he makes the statement about law of the case, and that's probably better applied to legal conclusions. I get that. But what about his blanket statements about reading it? And these experts did not examine him, right, between the first and second hearings? So help me with these simple facts.
The defense experts did not examine him between the first and second hearing, but the reports contained historical information about the history of his delusional beliefs, which is very important in deciding if somebody is competent. It's not a snapshot of what the person looks like today. it's a factor, but what also matters is the history of the person's medical history and mental.
Well, wasn't the district court judge concerned, and maybe rightly so, that the defense was just looking for a do-over? That there was no new information. This was just wanting another bite at the apple. There wasn't, as Judge Benton pointed out, there wasn't new information that was being brought to bear from re-examination. This was just the experts coming back with, as you say, providing maybe some more historical information, but rendering additional opinions. And the judge said, perhaps the wording was inartful, but speaking in terms of law of the case, can that be understood as the district court judge merely saying, we've been down this path and we're not going down this path again because I've rendered my decision?
Well, that goes back to what Judge Benton asked, which is, excuse me, the comment that the court made that it had already read all of those reports. It couldn't have read all of those reports. It said, I read all of these at the first hearing. We've already been through it. The reports did not exist at the time of the first hearing. They were only completed on December 28th and December 30th, just before the January 2nd hearing. Same with Dr. Ballinger, who said that he had considered all of those reports and took them into account at the first hearing. Again, the reports did not exist. He later corrected himself and clarified that he didn't because he couldn't have. Now, yes, both the court and Dr. Ballinger said they read those reports, but there's no evidence in that from the court's opinion. The court's opinion focuses on what Ballinger said and what Mr. Roof himself said. And
well, we could probably fairly take Judge Gergel at his word if he says I read them, couldn't we?
We could, but...
Okay, so if he read them, then isn't it fair to believe he also considered them? Not that he read them and immediately blocked them from his mind, but he read them and he considered them.
No, because in Antone, or actually it was in Wooden, no, I'm sorry, it was Antone. The court mentioned evidence that was not substantively weighed. It talked about evidence that was heard. So yes, even assuming the court read the reports, what matters is that the evidence was not weighed against each other. So what this court said in Antone is, the government contends that the district court's consideration was sufficient because it adopted the factual findings. Even though the district court acknowledged its awareness of the testimony, that by itself does not indicate that it adequately considered its impact. So yes, the court said, I read the reports. But if you look at the court's opinion, there's no reference to, and it wasn't just a repeat. Dr. Moberg submitted a report, a very detailed report that contained neuropsych testing that had not been presented at the first hearing, and craniofacial measurement testing showing disruptions in Mr. Roof's cranium that indicated that he was suffering from schizophrenia and related disorders. He said that he had a frontal system, a brain dysfunction with psychosis spectrum features, and that he suffered core components of a psychosis.
Well, nobody's suggesting that you don't have evidence in support of the position that you took. At least I don't think so. And I didn't even understand the district court to be suggesting you didn't have evidence in support of the position that you took. I understood the district court's position to be the court was more persuaded that Mr. Roof was competent than that he was not competent, and that he was persuaded on that after having read the reports and, in the first instance, having heard the experts. So you certainly got evidence you could keep reciting, but I'm trying to circle back on the standard of review here and the clear error point, and I guess your assertion is because it wasn't laid out in some detail in a written opinion, that shows a lack of weighing, and that represents clear error. Is that it?